Senator Crapo.
Thank you very much, Mr. Chairman. Judge Gorsuch has shown himself to be a judge of unwavering commitment to our laws and to upholding the separation of powers defined in our Constitution. The American Bar Association prides itself on serving as a neutral arbiter of the standards of the legal profession in this country. And as we've all heard today, the ABA has bestowed on Judge Gorsuch its highest possible evaluation. Their report is full of excerpts such as the following. Judge Gorsuch enjoys an excellent reputation for integrity and is a person of outstanding character. I have known and interacted professionally with Judge Gorsuch since his appointment to the 10th Circuit Court of Appeals. In my experience as a judge, I cannot identify a person more qualified in every sense of the word to serve as an Associate Justice of the United States Supreme Court. And Judge Gorsuch believes strongly in the independence of the judicial branch of government, and we predict that he will be a strong but respectful voice in protecting it. The Judiciary Committee recently concluded a 4-day review of this nomination, in addition to hearing from Judge Gorsuch for over 20 hours. The committee received formal testimony from almost 30 outside witnesses. Thousands upon thousands of words were exchanged over the course of the hearing, all in front of the American people. What the people saw is a thoughtful, humble, and brilliant legal mind in the service of the public. In response to a question of mine on Tuesday, Judge Gorsuch said the following: I come here with no agenda but one, no promises but one, to be as good and faithful a judge as I know how to be. That is it, and I cannot promise or agree or pledge anything more than that to this Congress. That statement and the hearing as a whole confirmed Judge Gorsuch to be a man of great integrity, of the mainstream, an exemplary student of the law whose record shows that he is part of unanimous decisions 97% of the time and 99% of the time in the majority. For days, a number of my colleagues from the other side of the aisle have raised the possibility that he might have secret intentions to subvert the rule of law or to shred the Constitution from the bench. They've parsed single words for hidden meanings, imagined devious strategies emerging from concurring opinions, and searched for cloaked messages in his published writings. Judge Gorsuch has over 10 years as a jurist with 2,700 opinions to review, yet most of the debate was focused on just 4 or 5 cases. Let's talk about what Judge Gorsuch testified to under oath. In the face of repeated insistence that he take a position on how some case should be ruled, should have been handled, or should be handled in the future, he kept focusing on following precedent and following the law. On his first day, he gave no fewer than 8 assurances that he follows the law as a judge. By my count, on the second day, he gave at least 36 assurances that he looks to the law for his rulings. And on the third day, it was 29 more times. That's right. By my count, at least, he said 73 times in the hearing that he's committed to the law when he hears a case sitting as a federal judge. Still, many worried that he had a secret agenda to overturn long-standing legal precedents. Just in case some are confused, Judge Gorsuch mentioned no fewer than 97 times that he follows precedent as a judge, as he is bound to do. More than 160 times, Judge Gorsuch reminded the Senate and the American public what a proper jurist does: follow the law and the precedent. We even talked about the book he co-sponsored or co-wrote, The Law of Judicial Precedent, 942 pages of dedication to following precedent. During his oral testimony, he dedicated to, and these are his words, ruling as the law requires, reading the language of the statute as a reasonable person would understand it, and respecting precedent. And just to put all these questions to rest, he assured everyone that he is without secret agenda, none. In reviewing his record, it's clear to me that those who come before Judge Gorsuch receive equal treatment under the law. He said in his hearing, "When I sit on the bench and someone comes to argue before me, I treat each one of them equally. They do not come as rich or poor, big guy or little guy. They come as a person, and I put my ego aside when I put on that robe, and I open my mind, and I open my heart, and I listen." I asked him, as some had intimated, whether when he was nominated he was required by the president to make some commitment to the president as to how he would rule on some case or how he would resolve some issue. In fact, I expanded my question, if I call correctly, to whether the president or anyone at the White House or in the administration had made such a demand of him. His response to me was that he had not been asked to do so, and had he been asked, he would have walked out of the room. Judge Gorsuch will follow the law and follow precedent, as his career has shown. Let me turn quickly to just a couple of the issues that have been raised. Some have raised the issue of what they call dark money today, saying that there are some people and organizations who are so hopeful that he gets nominated and confirmed that they are actually spending money to support his nomination. That's true. What the opponents don't say is that there are other people and other organizations who are so opposed to his nomination that they are spending millions of dollars in opposition to his nomination. That's also true. And as our chairman said in his opening remarks, that's part of our system in America. And for those who are today claiming that because some support his nomination, that he must therefore be committed to their agenda, is simply false. Judge Gorsuch has shown himself to be a man of character and integrity who will follow the law and honor precedent. And let me clear up the Brown versus Board of Education attacks. There's been attacks then in the hearing and attacks here today saying that he won't say whether he supports the ruling and understands the issues in Brown versus Board of Education. Well, let me read his exact testimony to this committee in his hearing. On day 2, he stated, "Brown versus Board of Education corrected an erroneous decision, a badly erroneous decision, and vindicated a dissent by the first Justice Harlan in Plessy versus Ferguson, where he correctly identified that separate to advantage one race can never be equal." He went on to say on that same day, "Justice Harlan got the original meaning of the Equal Protection Clause right the first time, and the court recognized that belatedly. It is one of the great stains on the Supreme Court's history that it took it so long to get to that decision." On the third day, when the issue was raised again, as if that was not clear enough, he stated, "It is a seminal," Brown versus Board of Education, "is a seminal decision of the United States Supreme Court, interpreting the 14th Amendment, maybe one of the great moments in the Supreme Court history." Again, he said, "I've said it was a seminal question of the United States Supreme Court that corrected a badly erroneous decision and vindicated the original understanding and the correct original understanding of the 14th Amendment, and is one of the shining moments of constitutional history of the United States Supreme Court. That is what I've said." And then after it went on, he finally said, "We are all on the same page on Brown versus Board of Education, Senator." Notwithstanding all of the incredible support and the clear evidence that Judge Gorsuch is qualified, there are still those of my colleagues who are advocating for the extreme step of filibustering Judge Gorsuch's nomination. Many today have given reasons why they personally are going to vote no. But voting no is different from filibustering. The argument is being made that all Supreme Court justices are submitted to a 60-vote rule, not a 50+1 rule. That's simply not true. The opponents can attempt to indefinitely delay his confirmation, but they cannot defend this as regular or established practice. None of the current sitting justices were subjected to a filibuster. None. 2 were even confirmed with fewer than 60 votes, but neither were subjected to that procedural roadblock. When President Obama nominated Justices Sotomayor and Kagan, Republicans did not subject them to a filibuster. They received a straight up or down vote. The same was true when President Clinton selected Justices Ginsburg and Breyer. Republicans did not seek or demand a filibuster. Even Judge Bork did not face a filibuster. All senators had an opportunity to vote on his nomination. And although throughout history there have been a few, and I mean a few, examples of where filibusters were tried, a partisan filibuster has never succeeded in the Senate. Just a little bit of history. There wasn't even a cloture process on judges until 1949. Prior to that time, cloture was not an issue. Since 1949, there have been 4, exactly and only 4 cases in which cloture was sought, where a filibuster was sought to be sustained relating to a Supreme Court nomination. The first came in 1968 with the case of Abe Fortas when he was being nominated to be the Chief Justice of the court. That is not only the first, but the only case in which a filibuster was maintained. And it was maintained because it was bipartisan. In that instance, Justice Fortas, then under a serious ethical cloud, faced 19 Democrats who voted to block his nomination, almost as many as the 24 Republicans who also voted to block the nomination. That's a slender thread to hang arguments in favor of blocking Judge Gorsuch from the Supreme Court. Even Judge Gorsuch's harshest critics have never suggested a whisper of misconduct by him. The other 3 cases, by the way, were Justice Rehnquist in 1971, when the full Senate rejected the filibuster, Justice Rehnquist again when he was nominated as Chief Justice in 1986, when the full Senate rejected the filibuster, and Justice Alito in 2006, when 72 senators rejected the effort to try to filibuster a Supreme Court nomination. The argument that justices nominated to the Supreme Court are subjected to a 60-vote rule is simply false. I understand that some are disappointed by the outcome of the November election, but it's quite a stretch to try to make the argument that the Senate requires 60 votes on a Supreme Court nomination. In fact, this argument was reviewed by the Washington Post, which gave it 3 Pinocchios, calling this a false talking point taken to an absurd extreme and using verbal gymnastics to obscure the truth. This claim only received 3 Pinocchios is an undeserved kindness from the Washington Post. In Judge Gorsuch, we have a nominee who lives the American ideal of a modest jurist. He understands that his responsibility is not to suborn the powers of others, but to help deliver justice. Those who have encountered him as a legal advocate, as an adversary in court, or a presiding judge all praise his fundamental fairness and suborning of his personal views.
Was I watching?
His respect for the Constitution is not in question. His experience, his wisdom, and judgment are not in question. His capability to serve is not in question. Commentators from both the left and the right overwhelmingly respect his legal mind and vouch for his commitment to fair jurisprudence. Given Judge Gorsuch's judicial philosophy and his record as a judge, he would be a welcome addition to the Supreme Court, seeking cohesive decisions. His record on the 10th Circuit is strong. 5 of 6 of his decisions have been affirmed by the Supreme Court, including one which he wrote and 4 out of 5 on which he joined. Not many judges have the experience, temperament, and stellar record to match Judge Gorsuch. Fewer still can garner overwhelming endorsement from colleagues, peers, and observers from across the political spectrum. Some may try to distract from the central point that Judge Gorsuch is extraordinarily qualified and suited to serve as an associate justice. Others would like to discuss other things or make this nomination a proxy fight about other tangential matters. But my colleagues and I will vote on his nomination, not those distractions. And I encourage all of us to remember that. The Senate should be proud to add Judge Gorsuch to the Supreme Court. Thank you, Mr. Chairman.